Good afternoon, everyone, and welcome to today's webinar on navigating consent-based trademark filings in Thailand. We are thrilled to have you with us. My name is Kasamasi Watanakun, partner specialized in IP prosecution and commercialization here in our Bangkok office. I will be one of the speakers in today's event. Today, we'll be diving in special circumstances in practice, a playbook for consent-based trademark filings in Thailand. This session will provide you with consent-based trademark filings, actionable strategies for using letter of consent, and Section 51/1 mechanism to overcome trademark similarity citation, the subject that's increasingly critical for trademark owners and trademark practitioners operating in the Thai market. Today, I am honored to be joined by our expert speaker, who brings extensive experience in Thai trademark prosecution and IP strategy, Ms. Ruchiya Chomrat, Senior Associate at our firm. Before I begin, just a few housekeeping notes to keep the session run smoothly. This webinar is being recorded. Our participants are currently on mute to minimize background noise. You are encouraged to engage us by asking questions. Please use the chat function located at the bottom of your screen. All questions will be addressed at the end of the session. If time is running out, I'll follow up by email. Your feedback is incredibly important to us, so at the end of the webinar, a QR code will appear on the screen. Please take a moment to scan and share your thoughts. With that, let's get started with a bit of introduction of our firm. Tilikin Gibbons, we are the leading regional law firm established in 1890, making us one of the oldest law firms in Southeast Asia with over 130 years of continuous practice. Our offices span in Southeast Asia, including Bangkok, Hanoi, Ho Chi Minh City, Jakarta, Phnom Penh, Vientiane, and Yangon. For those of you who may not be familiar with our firm, Tilikin Gibbons is one of the oldest and largest independent law firms in Southeast Asia. We are a full-service law firm with extensive experience in IP, intellectual property, and our trademark practice is one of the most active in the region. We regularly assist multinational corporations, local businesses, and entrepreneurs in protecting their brands across Thailand and ASEAN countries. So this means that we frequently encounter situations where trademark assignments, license arrangement, and corporate restructuring create the kinds of similarity citation challenges that our today's topic was designed to address. The strategies we will share today come directly from our practical experience in handling these matters on behalf of our client. We hope this will equip you with the practical strategies you can apply or at least consider whenever you face similarity citation in Thailand. Consent-based filings are usually considered when there is an issue of similarities to earlier trademark rights. So I would like to begin a quick overview of how similarity citation works in Thailand. When an applicant files a trademark registration, the registrar at the Thai Intellectual Property Department conducts an examination. One of the most critical aspects of examination is checking for similarity with existing marks. Here is the key point I want you to first identify. The stage of the prior mark, whether it is registered or still pending, will determine what type of citation you will receive, and importantly, what strategies are available to you to overcome that citation. Another important point is that cross-class citations are explicitly stipulated under Thai law. This means that even if your trademark application is in a different class from the cited mark, you may still face a citation if the goods or services are considered similar or seem to have similar characteristics. For example, A registration in Class 9 for computer software may be cited against an application in Class 42 for software development services. Let us first discuss Section 20 citation. When the mark being cited is a pending registration, this means that it has been filed but not yet registered. The application examination is suspended under Section 20, Paragraph 1. Under this section, if the mark that is identical or confusingly similar to an earlier application, the latter application shall be kept pending until the decision on the earlier trademark is final. In other words, your application is not rejected outright, but it is going to be placed in the holding pattern while the fate of the earlier application is determined. If the earlier application is eventually rejected or abandoned, your citation may be automatically lifted and your application can proceed. On the other hand, if the earlier application is eventually registered, your Section 20 citation may convert into a Section 13 citation, and that is when you need to address it accordingly. So when facing a Section 20 citation, you may consider whether to transfer the cited mark if it's at all possible. This will eliminate the conflict altogether. This approach works well when the earlier application is willing to sell or when there is a business relationship that facilitates the transfer. Second option is to monitor the cited mark closely. If the earlier application faces its own challenges, such as an opposition or a rejection, you may benefit from waiting. You may also consider opposing such earlier application yourself to prevent it from being registered. A third option is simply do nothing and wait for the prior application to resolve on its own. This passive approach can be appropriate when the earlier application is unlikely to succeed, or when you have time on your side and do not wish to incur cost at this stage. If earlier application does not eventually register, you will face a Section 13 citation, which you would then have to consider an appeal to overcome the citation. As I mentioned that the first option to tackle a citation is to consider transferring the cited mark, the assign and assign back strategy is one of the practical strategies that we've used in Thailand. Understanding this strategy is also essential because it often works in conjunction with the consent-based filing under Section 51/1, which we will discuss later today. So here is how it works. Step 1, applicant owns a trademark application or registration. Step 2, applicant 2, who is aware of applicant's 1 earlier conflicting mark, assigns that trademark to applicant 1. This eliminates the conflict because now both trademarks are owned by the same entity, which is applicant 1. Then, applicant 1 will help applicant 2 with the prosecution and secure registration of the assigned mark before the Department of Intellectual Property. After the assigned trademark proceeds to registration, applicant 1 will assign back the mark to applicant 2, who has in fact always been the genuine owner of the mark. The end result is that both marks end up with respective registered trademarks, and the earlier conflict have been resolved through this temporary consolidation of ownership. This strategy requires cooperation between the parties, of course. It works best when the parties have a business relationship, for example, maybe a parent company or subsidiaries, or company that have entered into a coexistence agreement anywhere. So the assign and assign back approach might be time consuming and may involve multiple recording filings at the Thai DIP, but it can effectively overcome the similarity citation and can trigger eligibility of later consent-based filing under 51/1. Let us next look at Section 13 citations, which happens when a mark being cited is already registered. This is the more challenging type of citation to overcome because you are dealing with an established registered right. When you receive a citation under Section 13, it means that the registrar has determined that your mark conflicts with an existing registration and your application is already being refused. So when facing Section 13 citation, you need to choose the right way that fits your case. The first thing to consider is to whether discuss with the registrar whether a revocation of citation is possible. This works best when there are administrative errors such as citations against later filed mark or a lapsed trademark. A simple discussion might be able to resolve the issue. This approach also applies to inconsistencies in trademark owner's name or address, which must be rectified before the citation can be lifted. Common issues include Thai transliteration variations or punctuation differences in companies' names. Whatever you do, the most important thing is that do not miss the deadline. Otherwise, your application will be abandoned. This is unlike the case of Section 20 we earlier discussed, where you may just do nothing and miss the deadline and your application would still be alive. Now, if the revocation of the citation is not possible by talking to the registrar, it is time to consider filing an appeal with the Board of Trademarks. Since the rejection is based on similarities to earlier trademarks, arguing that the marks are dissimilar is certainly important. But what you may also do is trying to get your marks accepted in coexistence with the cited earlier mark based on reason that you have been an honest and concurrent user of your mark for years without causing public confusion. Or you may say that there are special circumstances under Section 27, following which the registrar should allow coexistence of confusingly similar mark by mandating specific conditions or scope of existence. Let me turn to Section 27, which is critical for understanding consent-based filing in Thailand. This section provides the legal foundation for allowing the coexistence of similar marks under certain circumstances. Specifically, when there are applications rejected under either Section 13 or 20, the registrar finds that there has been honest and concurrent use or special circumstances. The registrar may grant registration of identical or similar trademarks belonging to several owners in coexistence. The registration granted under Section 27 may be subject to conditions or limitations as to the mode or place of use or other conditions as the registrar may see fit. For example, the registrar may require that the marks be used only in specific geographical regions or only in connection with certain goods or services, or with distinguished elements to minimize the risk of public confusion. The registrar must notify the applicant and the registered owner of the mark in writing so that it is transparent in the decision-making process. Here's an important piece of history for better understanding of our today's discussion. Before the 2016 amendment of the Thai Trademark Act, special circumstances, as mentioned under Section 27, was not legally defined, but it was dependent solely on the registrar's discretion. This created uncertainty for practitioners because there was no clear guideline on what would or would not qualify as a special circumstance. The amendment in 2016 addressed this uncertainty somewhat by introducing Section 51/1. which specifically stipulates one instance of a special circumstance, being it acquiring a written letter of consent from the owner of the cited mark. This was a significant development because it provided a clearer, more predictable pathway for obtaining consent-based filing in Thailand. The guideline to examination of trademarks, which corresponds to the further elaborates on the particular of the letter of consent required to invoke Section 51/1 and also provides example of other special circumstances to further clarify Section 27. Beyond the consent-based filing under Section 51/1, other special circumstances as recognized by this guideline is that the first recognized special circumstance involve trademarks that are continuously used by the owner without renewal after expiry. In other words, if a trademark registration has lapsed because the owner failed to renew, but the owner continues to use the mark in commerce, this ongoing use may constitute as a special circumstance that may justify allowing re-registration of the refiled mark. This situation is not uncommon. Sometimes the trademark owners may inadvertently miss the deadline due to oversight or the changes of personnel or miscommunication, whatever. This guideline recognizes that it would be unjust to bar such owners from re-registering the marks that they have been using for a long time in good faith. Second special circumstance recognized by this guideline is national popularity through distribution or promotion without legal challenges from the other rightful holder. This applies when an applicant can demonstrate that their mark has achieved widespread recognition in Thailand through extensive commercial use, advertising, and promotion, and that this use has occurred without any objection from the owner of the cited mark. The absence of legal challenges suggests that the market in general has accepted coexistence of the mark without confusion. To successfully invoke this type of special circumstances, applicants typically need to provide substantial evidence of their market presence, including sales figures, advertising expenditures, media coverage, consumer surveys, or other documents that show the use in long duration and in geographic scope of their use in Thailand. The evidentiary burden can be significant. So this path is generally most viable for well-known, well-established brands with documented history of the use in Thailand. The third special circumstance may arise from the changes of classification based on the Ministry of Commerce new notifications. As you may know, the classification of goods and services under this classification system has evolved over time, and sometimes there may be updated classification through the ministry notifications. When such a notification merges previous classes or reclassifies certain classes of goods and services, it may create new conflicts of marks that were previously in separate classes before. In such situations, the administrative changes, rather than any fault of the applicant, may justify treating the situation as a special circumstances. This recognizes that it would be unfair to penalize trademark owners for conflicts that arose solely due to government reclassification decisions beyond their control. The fourth special circumstances is final court decision permitting acceptance of the application. If an applicant has obtained a court judgment, whether from the Central Intellectual Property and International Trade Court or from the Supreme Court on Appeal, that supports the acceptance of their application. This judicial determination constitutes a special circumstance that the registrar should respect. This ensures that administrative trademark systems honors the decision of the judiciary. It is worth noting that these 4 special circumstances are not necessarily exhaustive. The language of Section 27 refers to special circumstance generally, so the guideline only provides examples rather than a closed list. However, in practice, the registrar tends to apply these provisions conservatively, and the applicants should generally expect to fit within one of these recognized categories. If you believe you have a unique special circumstance not covered by these examples, you may try. It may be worth making the argument, but be prepared of the possibility that the registrar may not accept it without clear precedent. So now let me explain another special circumstance, which is the consent-based filing under Section 51/1. This section is the primary focus of today's presentation. It applies in a specific situation. It covers cases where assignor, assignee, or inheritor of a trademark files an application for a mark that is identical or similar to a trademark they assigned, accepted, or inherited before. This applies whether the new application is in the same class as the earlier trademark or in related class having the same nature. Critically, to invoke Section 51/1, the applicant must have received a written consent from the other party, whether the assignor, the assignee, or the inheritor. Let me break down this into practical example to make it clearer. Imagine Company 1 owns a registered trademark. Company 1 assigns that trademark to Company 2, perhaps because Company 2 is a subsidiary, or because there was a business transaction between them. Or it could be the other way around, in which Company 2 may be the one assigning the existing trademark to Company 1. Anyway, with that assignment, both company is considered either an assignor or assignee of an earlier mark already. Later, let's say Company 1 wants to file a new application for a similar mark in a related class. Under the normal circumstance, Company 1's new application would be cited against Company 2's registered trademark, despite that mark is the same mark that Company 1 originally owned and assigned away to Company 2. This could be a citation under either Section 20 or Section 13 we have discussed earlier. Section 51/1 now provides a solution to possibly overcome the citation. If Company 2 provides a letter of consent agreeing to Company 1's new registration, this would constitute as a special circumstance under Section 21 plus Section 51/1. And the registrar should now allow Company 1's application to proceed. The key insight here is that Section 51/1 is designed to address situations arising from transfer of trademark rights. It recognizes that when parties have prior assignment or inheritance relationship, the consent to coexistence is meaningful and should be respected by the trademark system. According to the guideline, the letter of consent must contain certain information to be valid. Getting these details right is essential, and as an incomplete letter of consent may not be accepted by the registrar. The first requirement is that letter of consent must include details of the assignor, assignee, or inheritor of the trademark application. This means clearly identifying the parties and their relationship to the trademark in question. Importantly, there must be an uninterrupted series of assignment or inheritance. If the trademark has changed hands multiple times, the chain of title must be complete and documented. Any gap in this chain could undermine the validity of letter of consent. The second requirement is that the letter of consent must include details of the date of the assignment or the date of inheritance. This date is crucial because it must be before the date of filing the new trademark application. The registrar will verify this timing requirement. If the transfer occurred after the filing date, Section 51/1 will not apply. This is a strict requirement, so practitioners must pay careful attention to the chronology. The third requirement is that an original letter of consent must be submitted. If you are filing multiple applications that rely on the same letter of consent, the original letter must be submitted with the first application and copies may be submitted for the remaining applications, but make sure that you reference the original submission in your subsequent filings. Fourth, the letter of consent should be submitted to the registrar, not to the Board of Trademarks. This is a procedural point, but it is also important. The letter must be submitted anytime at the time of filing application or after receiving a rejection. If you anticipate a rejection, maybe it would be more efficient to submit the letter of consent upfront during the filing of the application. Section 51/1 consent-based filing mechanism is relatively unique in ASEAN. Because of this uniqueness, we talked about this section today. Having said that, I must say that practical legal principles I have discussed, while it may sound straightforward in theory, the practical application of this section is not always simple. Now I will let my colleague share with you what we have found in real life.
Thank you, Kasma. Let me now walk you through some real cases to illustrate how Section 51/1 and related strategy works in practice. These case studies help you see how the concepts we have discussed apply in the real-world situation, and they will highlight some pitfalls to avoid. Let's start with the first case. Company A filed application number 1 for the mark Apex in Class 9 for computer software. And later, the registrar refused the application for being similar to Company B's identical mark, covering software and the design and development of computer software in classes 9 and 42. The citation was issued because the marks were identical and the goods and services were directly overlapping. USA computer software in Class 9 and software development services in Class 42 are closely related from a consumer perspective. Company A had an option to file an appeal. However, it was unlikely to succeed in arguing dissimilarity or seeking coexistence under Section 27, given that the marks and the goods and services were identical and substantially related. This is a classic example of a similarity citation that would be very difficult to overcome through a dissimilarity argument alone. When the marks were identical and the goods and services overlap substantially, the registrar's refusal is almost certain to be upheld by the appealer if the applicant simply agrees that the marks are not confusingly similar. This is why Company A needed to consider the alternative strategies. As a result, Company A decided to pursue the assign and assign back strategy through the following steps. Filing a pro forma appeal with the Board of Trademarks to keep the mark Apex in force. Submitting a deed of assignment transferring the mark to Company B. The board issuing a decision confirming the assignment by removing the similarity issue. the mark being advertised in the Trademark Gazette and subsequently registered. Company B assigning the trademark back to Company A. This affects the intended completion of the assign and sign-back cycle. According to Section 51/1, once the first assignment is recorded, the foundation of relying on Section 51/1 is established. Company A's subsequent applications containing similar words, together with a letter of consent from Company B, should then be accepted without citation being raised. However, in this case, the story did not end there. Let's see in the second case why. While the Company A was waiting for the board's decision resolving the similarity issue following the assignment of its APEC marks to Company B, they attempted to rely on a mechanism of Section 51/1 by filing a second application for APEX dual in multiple classes, specifically in classes 9, 35, 38, 39, 41, 42, and 45. Along with this, Company A submitted a letter of consent from Company B permitting the use and registration of APEX dual in classes 9 and 42, which were the same class covered by Company B registration. Unfortunately, the registrar still cited Company B's APEX marks against APEX dual application, reasoning that the letter of consent covered only classes 9 and 42, while the services in class 35, 38, 39, 41, and 42 were considered related to Company B goods and services in classes 9 and 42. As a result, Company A again chose to forego an appeal and pursue the assign and sign-back approach, and agreeing to this came the Commonwealth dual. Here comes to the third case, illustrating another pitfall, this time being related to timing and completion of prior transactions. Company A filed a third application for APEX trio in classes 9, 35, 38, 41, and 42. Having learned from the APEX dual experience, Company A obtained the letter of consent from Company B, covering all relevant classes 9, 35, 38, 41, and 42. It seems the scope issue was addressed, but a different problem arose. The registrar again rejected APEX trio as being similar to Company B APEX registration on the grounds that the assign and assign back transactions relating to the first APEX and the second APEX dual had not been fully completed. Therefore, this was not a situation in which registration could be allowed under Section 51/1. As a result, Company A chose not to appeal, but instead pursued the assign and sign back again, and agreed to disclaim the Commonwealth trio. Now let me share a few cases where Section 51/1 was successfully applied. These examples provide good models of how the mechanism is intended to work. Company A, being the parent company, held the register mark KIN and assigned it to Company B, which is its subsidiary. This is common in multinational corporate groups where trademarks are assigned to local operating companies for business reasons. Later, Company A sought to register a new trademark for KIN Light through the MADIT protocol designating Thailand. However, the application was rejected by the Thai registrar for similarity to the trademark KIN, which was now owned by Company B. This situation was precisely what Section 51/1 was designed to address. Company A was a signer of the original trademark and was now applying for a similar mark with the assignment relationship already established. Company A then submitted a letter of consent together with an appeal to the trademark board. And the trademark board found that the requirements of section 51/1 were satisfied and ruled in favor of company A. So the Keen Light trademark proceeded to registration. You see that this case was textbook perfect because the original assignment to the subsidiary occurred before filing the new application, and thereby meeting the key timing requirement. And let me share one more successful case to reinforce the principle discussed. The parent company C held a registered trademark poll and assigned it to the affiliated company D as a part of the corporate restructuring. Later, company C filed a new trademark application for poll extra, together with a letter consent from the company D. And very fortunately, the registrar accepted the letter and poll extra proceeded to registration smoothly without the need to file an appeal. And next, Kasama will wrap up this topic with the key takeaways and success of failure factors regarding section 51/1.
From the case studies we have just shared, we have found some pain points and variables that can affect whether your consent-based strategy succeeds or fails. First, the business relationships between the parties contributes to the registrars or the boards of trademarks acceptance under section 51/1. While the statutory requirement of section 51/1 are technical assignment or inheritance relationship and a letter of consent, the registrar may also consider the broader context. A clear parent-subsidiary relationship, for example, may be viewed more favorably than a relationships between an unrelated party. The registrar wants to ensure that section 51/1 mechanism is being used for its intended purposes, not as a workaround to circumvent the similarity examination. Second, there is an open question that practitioner often asks. Should assign back be completed before new applications are filed along with the letter of consent? As we saw in the Apex Trio case study, incomplete prior transactions can create problems. However, the answer may depend on the discretion and interpretation of the individual registrar handling the case. Some registrars may take a strict view, while others may be more flexible. Provisionally, once the first leg of assignment is filed for the first mark, the applicant's second or later applications along with the letter of consent should be accepted. Nevertheless, not every registrar construe the provision of section 51/1 in this way. Some may argue that the second leg of assignment or the assigned back must be recorded first for the subsequent applications to be allowed together with the letter of consent. This uncertainty is one of the challenges of working with section 51/1, and it underscores the importance of careful planning and sequencing. Third, timing is critical throughout the process. The transfer or inheritance must take place before the filing date of the new application. If you file the new application first and then tries to arrange the assignment afterwards, the consent-based filing strategy will not help. This sequence matters. Missing a deadline or getting the sequence wrong may affect your entire strategy. Fourth, the quality and completeness of your documentation also matters. The letter of consent must contain all required information. Any gaps or inconsistencies may give registrar grounds to reject your section 51/1 claim, as in the case of Apex 2.0, where not all classes were covered. From our presentation today, we view that the approach under section 51/1 would be most effective when the new mark is very similar to the cited mark in core elements, which makes this similarity appeal unlikely to succeed, and the marks are in the same or related class, and alternatives such as cancellation or purchase of the earlier marks are not feasible. Remember that only assignment or inheritance relationship qualify under this strategy. Merely being affiliated companies or other relationships do not qualify to use Section 51/1. If necessary relationship does not exist, the assign and assign back strategy may be needed to create it first. If pursuing a consent-based strategy, document the assignment or inheritance relationship thoroughly. Obtain a letter of consent covering all relevant classes. Verify timing requirements and maintain records of the chain of title and transaction dates because the registrars will scrutinize all these details. Lastly, before choosing to use the consent-based strategy, you will need to keep in mind that this strategy would likely require continued cooperation between parties for future filings. Consider this long-term commitment before proceeding and assess whether such cooperation is realistically achievable. Now, if you have questions, please use the chat function located at the bottom of your screen, or you may send up follow-up emails. Our email addresses appear in this slide in case you have any questions later on. We would like to thank you very much for everyone who attended. And if you have any follow-up questions, please feel free to reach out to us at Tillikin Gibbons. Again, we thank you for your time for today.